everybody.
Hello. Those of you joining us online, welcome to LABOR.A. Herzlich willkommen. Ja, ich kann immer noch Deutsch eigentlich. But this session will be in English. I don't know if there's translation or not. If there is, I'll try to speak slowly for the interpreters. If not, I hope that's okay with you. I'm Silberman, this is Joanna Bronowicka, and Justin Nogarede, who's going to pronounce his last name properly in the future. Thank you. And today we're going to talk about resisting algorithms, legal strategies to protect and empower workers in the age of algorithmic management. Algorithmic management, what is it? Why is everybody talking about it? Why are we resisting it? Algorithmic management is the use of computer systems to make or significantly inform decisions in the workplace. This includes decisions in recruiting, hiring, assigning work, evaluating work and workers, promoting workers, and firing, or in the case of self-employed workers, otherwise terminating the employment relationship. Algorithmic management also includes other business decisions, such as designing delivery routes, locating and laying out facilities, and deciding how many workers to have on site at a given time. Why are we talking about this? First, algorithmic management seems increasingly to be everywhere. It's been documented in so-called blue-collar work, such as warehouse work, retail, manufacturing, and logistics, and in white-collar work, such as engineering, marketing, and consulting. It's also being used in the public sector, for example, in healthcare, and particularly salient if you follow the news out of my home country, the United States, policing. Algorithmic management could be used to benefit both workers and organizations, but in many cases it appears it is not being used in that way. Rather, the ways algorithmic management is being used are creating harms and risks for both workers and organizations. It's being used in ways that are creating health and safety risks for workers, both physical and psychological. It's being used in ways that erode trust between workers and management, making organizations function poorly and eroding human dignity in the workplace. It is destabilizing established labor market institutions such as trade unions, social dialogue, co-determination, collective bargaining, and in some contexts, it is even calling into question our basic understanding of what an employment relationship is. In some cases, algorithmic management is being used in ways that are unlawful, that violate existing laws such as labor law, discrimination law, and data protection. And in some cases, I might even say in many cases, it appears that the algorithmic systems being used do not even do what they are supposedly being used for. There are very lively discussions among policymakers, trade unions, civil society, and researchers about what should be done to address these harms and risks and to ensure that algorithmic management benefits both workers and organizations. There is an emerging consensus that policymakers probably must take some action. However, it is not yet clear what that action should be. This panel is part of these discussions. Before we start, I will say one thing. I was asked in these remarks to say something personal. Obviously, this is an important policy topic. We're all trade unionists, policy researchers, but why are we really bothering to talk about this? I was a trade unionist for 5 years, and I'm still a trade union member, and I've also worked as a computer programmer. So with this background, I'll say 3 things, but they'll make the most sense if I tell a brief story first. It's a very sad story, and unfortunately, it's a true story. Some of you might know it already. It takes place in Italy. On October 1st, 2022, an Italian courier named Sebastian Galassi got on his moped in Florence to make a delivery. He was working through an app called Glovo. If you don't know Glovo, it's like Foodora or Deliveroo. It's one of these restaurant apps. While he was making the delivery, he was hit by a car and killed. Later in the day, Glovo sent an automated email to his email address. It was seen by his family. The email informed him that his account was being deactivated. He was being fired because he had failed to uphold the terms and conditions to which he had agreed when he started working on the app, because he had failed to complete the delivery. In the protests that followed on the streets of Florence, one courier held up a sign that said, "My life is worth more than the price of a sandwich." So what can we say? 3 things. First, when we talk about occupational health and safety, I know many of you know this, but it bears repeating. This is a very technical, legal-sounding term, but we should be very clear that when we are talking about algorithmic management and regulating algorithmic management, this is a matter of life and death. It sounds dramatic, but it's true. Second, one way to think about the struggle to regulate algorithmic management effectively is that it is a struggle about the meaning of technology in the work relationship. Will technology be used to balance the relationship of power between workers and the employer, or to make it even more uneven than it already is? Will technology be used to make work more humane, or to make human workers behave more like robots? Will technology be used to protect workers' health and safety, or to give managers greater ability to pressure workers to work faster at the expense of workers' physical and psychological health and safety? And third and finally, the struggle to regulate algorithmic management is a struggle to protect the dignity of work and the dignity of working people. Beyond health and safety, this, I think, is one of the great functions of labor law, trade unions, and labor market institutions. And I think the body of norms we are developing to regulate algorithmic management has this function as well.
Thank you, Six. Thank you, Six, for these powerful remarks, for this introduction to our session, and for reminding us for why we talk about sometimes these very technical topics. I will now tell you how the rest of the session will be structured. Each of us will make short remarks, and at the end, you will be invited to share your questions or remarks too. Also, the people who are watching us online, you can write your questions in the chat. We will begin with Justin, who will tell us what the public authorities can do to better enforce existing laws, in particular data protection laws in Europe. And then I will talk about what the workers and the unions can do, or more specifically what they have done already, especially the platform workers from the food delivery sector. And then we will turn back to Six, who will tell us what the legislators can do, in particular the EU legislators. So with that, I turn to Justin.
Thanks a lot, Joanna, and thanks for joining this session. Indeed, I'm Justin Nogarede. I work for the Friedrich-Ebert-Stiftung Competence Center on the Future of Work. And before I worked in the Commission on the enforcement and application of EU law, so that's a bit my beat. When we talk about algorithmic management systems, why do we talk about existing laws? Why do we talk about GDPR? Well, because a lot of algorithmic management systems they process personal data of workers. So the GDPR applies. Yeah? When you talk about, personal resource management systems, systems to score workers, fire and hire them, this is all about workers' personal data. Luckily, the GDPR has a lot of protections and rights for workers in this space. I will not go in detail, but just to say that, for instance, employers are obliged to share proactively information to workers about the purposes of processing of personal data, the nature of that processing, and so on and so forth. Workers also have rights to access their data, and they can also, for instance, opt to be judged, let's say, by a human instead of by an automated system. So there are some protections in there. But then, of course, the big question is, how does this work in practice? The law gives tools for workers to understand and resist the algorithm. How does it work in practice? Spoiler alert, it doesn't really work all that well. And that brings us to enforcement. Just put up, actually, the next slide. There's a huge amount of non-compliance when we talk about data protection in the workplace. I don't want to promote our own work, but I will do it anyway. Also in the chat, I'll post a link. We did a study last year that was also presented here at LABOR.A, where it showed that already at the basis, at transparency, things are going wrong. So a lot of workers have actually no clue about the processing of the personal data, the nature of that, or how algorithmic systems work in the workplace. They are simply not being informed. So already at the basis, this goes wrong. So what then should authorities do? In this case, the data protection authorities, which are the, let's say, the institutions that are entrusted with the enforcement of the general data protection regulation that we're talking about here. Well, I will say there's 3 things that they can do, and I will go into that in a little bit more detail. But I also think there's structural limitations, and I will end on those limitations. So let's have a look. I think first, and this is very basic, they should simply focus on the workplace, which they're not really doing all that much at the moment. So if you look at the annual reports, if you look at their activity reports, programs for the coming years, you see that employment is rarely ever the focus, which to my mind seems very surprising, given that since COVID especially, we have a very rapid digitalization of the workplace. So for me, this would be crucial to focus on that. Another thing about prioritization is that DPAs often focus on small cases. But the big systems that millions of workers use across Europe, they're not really being tackled. And what's really interesting is that we're now in Germany, is that the conference, okay, this is an English translation, I'm not sure it's correct, the Conference for State and Data Protection Authorities, so it's essentially, in essence, all the data protection authorities in Germany coming together. They already investigated, for instance, Microsoft 365, that is used amply across Europe, and they found that they could not vouch for the legal use of those systems, of that system, with the implication that it shouldn't actually be used. This is a year ago, almost. And since then, there's been no enforcement action. This is also not new. People know this. Other authorities in France, across Europe, have looked into this. And people know this, but there's no enforcement action. And I would say this is really low-hanging fruit to start looking into that. So that's the first point, focus. And the second point is also about effectiveness. So once DPAs do actually act and they look at data protection in the workplace, often their decisions are not public and they're kind of sparingly with the use of, they're reserved about using fines. So their decisions have limited effect. For instance, again, we're in Germany, we take the Zalando case a few years ago. As Zalando, big e-commerce firm, they used performance management system called Sonar. The Berlin Data Protection Authority decided to investigate after a bunch of complaints and action from academics. And they helped and put significant resources in making sure that the system was compliant. But that didn't result in any public decision. So that also means that other firms cannot learn from this. Also for other authorities, it's more difficult to understand, what happened, what they can take home from that. So it's the effect of that is just very limited. And in the end, there was also no fine. So that means that in the future, if I was Zalando, I would take home from this that I would have very limited incentives to proactively comply because there's no risk. So just wait for them to come to you, draw it out a few years and only act when you're absolutely forced to. So that's the second point, effectiveness. And the third point is cooperation. So right now, there's actually no database with publicly accessible decisions from DPAs and courts on data protection at the workplace. And that, I think, is a huge missed opportunity, both for other DPAs so that they can learn from each other's work. I mean, there's, of course, some unofficial cooperation going on, but this is, again, time-consuming. But this is also important, I think, for unions, for workers, for works councils, that they can see actually easily accessible on specific topics what has been decided and how DPAs interpret the GDPR. This could help a lot and also save resources for DPAs, right? Because then they would have less litigation. So those are, for me, 3 big points where we can, still make a lot of steps. But as I said in the beginning, I think there's also clear limits. One is obvious. It's the fact that funding is simply limited, right? DPAs cannot fulfill the tasks that are legally mandated to do. I'm Dutch. The Dutch DPA is one of the best resourced, and they openly admit in the annual reports that they can't follow up timely on complaints. To greenlight permits for data processing outside the EU takes more than 7 years. So that's completely not functioning. That exists on paper, but it's not a reality. And of course, those businesses are not going to wait 7 years. Is Facebook going to wait 7 years? No, of course not. So this is a big problem that I don't think structurally will be solved because there's no political will to really increase the budgets to such an extent that this can be solved. The second point is that cross-border enforcement is also not really working. Right? The DPAs that have the least interest to actively enforce the law have the biggest responsibility. For instance, Ireland. Right? Microsoft headquartered in Ireland. Google headquartered in Ireland. So that, of course, also creates blockages. That there's some work to solve that with a new regulation, but I'm really quite skeptical. So we'll see how that goes. Third final point, I think also the technical ecosystem is optimizing for the opposite values. So the GDPR says, purpose limitation. Be careful what data you collect. You need a legal database. But of course, the entire internet almost, all the workplace software, and this is to a significant extent also the culture that comes from the US, is optimized for the opposite goal. It's maximum data hoarding for specific future speculative purposes that you don't know now. And I think that is very difficult in that context to enforce. Every lawyer knows that you cannot really enforce a law if there's such massive non-compliance. You always need the majority to simply apply the law and share the norms that you want to enact. So I think these are a few big problems that we cannot just solve or rely on the DPAs to solve. My pet peeve is really that we should look more into standardization. So I think also unions should get more active in kind of laying down the technical requirements that they want to see for software systems. This sounds very technical, but for instance, you have it for eco-design, right? You have requirements for fridges that they work in a certain way that they don't consume too much energy. It's very boring, very technical, but you could create certain similar things for, I don't know, data protection at the workplace. Unions could come together and say, this is what I want to see in a system, we'll give a seal, and then you also create some market power to actually enforce that. I think that would be, for me, a future way to address this. And the second point is that unions, workers, works councils, labor representatives should be much more active in really resisting the algorithm and using the law and the possibilities in the law to take on the fight. And here, Joanna will continue on that note.
Thank you, Justin, for giving us this perspective. For this perspective of what can be done from top down, I want to focus on what can be done from the bottom up, what has been done by workers. My name is Joanna Bronowicka. I work at the European University Viadrina. I'm a sociologist who studied platform workers since 2016, so basically since platforms arrived and changed our labor markets. And I want to focus on the lessons we can draw on from the resistance efforts that have taken place in these last 6 years. Here quickly an academic definition of resistance. Bear with me for a minute. This definition focuses on the fact that revealing and questioning the parameters of power, how they operate, is already resistance. So this is exactly what the platform workers have done through innovative, creative ways. They focused on how they can reveal and question the parameters of power, in this case, literally the parameters that the algorithms use to evaluate their work. So the first example, I want to give 3 examples of interesting and innovative practices. The first example comes from our own research. This was resistance at Deliveroo and Foodora here in Berlin. We noticed very early on in our research that workers will try to figure out what the rules are, how the algorithm works, by playing sort of trial and error. And through this guessing, they also figure out how you can bypass the algorithm without being punished. And this can, of course, be an individual behavior, but very often, very early on, it was something that the workers shared with each other in solidarity. So, for example, they would learn how to mask their GPS location in order to avoid being punished for being late or missing their shift, and share this on WhatsApp groups. Or they figure out that the good performers were given access to better shifts, and they would, in solidarity, share these shifts with the ones that were considered bad performers. So this is something that we've seen in research has happened around the world, because there have been more than 500 cases of global unrest of food delivery platform workers alone around the world. And this clearly counts as resistance, even though it's hidden from the public eye, because it has this political intent. It is to defy the logic of platforms, which use algorithms to sort workers, to evaluate their performance, but also to put them in competition against each other. The second set of resistance practice was pioneered by Worker Info Exchange in the UK. And it draws on this rights that workers have as digital subjects in the meaning of the GDPR, of data protection laws. This legal framework gives workers a right to request a copy of their own personal data through a procedure called data subject access requests. So companies are not usually eager to share this data at all, but when they get this formal request, they usually respond by at least partially explaining what data is collected and in which cases automated processing is used. Now, what Worker Info Exchange has done, and other organizations since then, is that they use this data to build strategic litigation cases. For example, the cases in Amsterdam court were very helpful because the ruling in the case of the platform called OLA was the first time the Article 22 that regulates automated profiling was used. And whether these cases are actually successful for the worker that is concerned or not is, of course, they are not always successful for the workers, but they are very helpful for clarifying the rules for all of us. Because the court have this unique ability to compel the platform to tell us more, and this is what they did in the OLA case. They requested the platform to reveal more information about their internal architecture. So I think this form of strategic litigation is very promising. But what else can be done if platforms do not want to share this information? Here I want to share with you an analysis that was we conducted with the help of technical experts at Tracking Exposed to show you that relatively simple and cheap methods can be used to investigate, to reveal how these apps work. So yes, it is true that we cannot look inside the black box. But through this method that is called black box method that was developed in the digital security field, we realized that we can take the app that the worker uses and look at the input, so the data that the app is pulling from the phone, and then we can also see what data is shared across the network. And what we found out is that, and this was analyzing a single worker, is that the app was pulling copious amount of data, in particular location data, and even outside of working hours. So this is clear violation of the GDPR, and it was sharing the data with not only back to the platform, but also to marketing companies. So this kind of technical evidence, as I said, it's a relatively straightforward method that can be easily replicated, generated evidence that we then submitted to the Italian DPA. What happened at the time, DPA had just finished their own investigation into the Glovo, or rather the subsidiary of Glovo in Italy, Fudigno, and decided to fine them with 2.6 million euros. So this case is still pending in court, but it ties back to the point that Justin made, which is that, you know, DPAs need technical expertise, but also workers can need technical expertise, but probably the best effect we would have if there's some kind of synergy between these two. So to conclude, what are the lessons that we learned from platform workers that can be helpful in other types of workplaces and for unions? First of all, workers have a lot of knowledge. I don't think that they need to be educated about algorithms. I think, in fact, they have the best knowledge about how the algorithm works, so we can learn a lot from them in, for example, collective bargaining efforts. Second of all, technical experts are very important because they can help to audit and analyze the algorithmic management systems. And the community of such experts is there and it's growing. And I think unions can play an important role in embedding them in existing worker organizing efforts. Finally, a lot has been done to test the method of strategic litigation through individual cases, but unions have this unique ability to test collective rights by building union-based court cases. And I think, of course, the primary strategy of unions they can rely on is collective bargaining, but it's not always possible not in all countries and all sectors. This is the strategies available. So I think strategic litigation, whether done by individuals, NGOs, or unions, can really help to expose gaps in existing laws. So to sum up, we're a really interesting moment in history because platforms provided kind of a shock to the system, to existing laws and institutions, and this led to emergence a lot of interesting new actors and practices. And now we can learn a lot from this about the gaps and how these laws and institutions should be reformed. And with that in mind, I transfer to Six, who will talk about legislative initiatives. Thank you.
Thank you. Great. So I'll talk for about 5 minutes. I'll talk about 4 gaps in existing law at the EU level and what the legislator can do about each one. These remarks are based mostly on this paper, so if you're into reading papers from the European Labor Law Journal, I'll leave that up for a second. The 4 gaps are, first, the legal bases of workplace data processing, collective data rights, for example, the rights of worker representatives, such as the Works Council. That's working? Yeah, great. The right to an explanation for automated decisions, especially at work, and the validity of workplace data processing. So, first, legal bases. All data processing is governed by GDPR. This includes at work. I'm not going to read this, don't worry. Employers must choose a legal basis for processing workers' personal data. This is the piece of GDPR that says that they have to do this. GDPR sets out 6 possible legal bases. These are all of them. One of them at the bottom is the legitimate interest of the controller. At work, the controller is the employer. The problem here is that legitimate interest is not well defined in the law or in case law or in guidance. And Amazon, for example, argued recently in Nita's auction that it has a legitimate interest in constantly monitoring at 5-second intervals workers' physical locations and activities. And the Data Protection Authority said, no, you don't. And then the administrative court overruled the Data Protection Authority, and now the Data Protection Authority is going to have to appeal the decision. So the problem is the law does not draw a clear line between what is legitimate and what is not legitimate. So that's a problem. Another legal basis is consent of the data subject. At work, the data subject is the worker. GDPR says for consent to be valid, it must be freely given. However, a lot of legal scholars have said, well, it's not really clear if it's possible to freely give consent to your employer because you have no idea how your employer might punish you for not giving them consent to do something that they want to do. This is not a new idea, but the question is, what can the legislator do? Well, the legislator could set very strict rules about when both of these legal bases could be used for workplace data processing, or the legislator could just say, these legal bases are not allowed to be used for workplace data processing. We have argued that they should not be allowed. This would create much greater legal certainty. Some legal scholars have taken a more nuanced perspective, but that's ours. Second, collective data rights. How does paper work? Yes, there we go. So data protection law is very individual. All the rights are individual. It was actually envisioned in GDPR, when it was written, that EU member states would create collective data rights in the workplace at national level. Why do we know this? Well, Article 88 says, dear member states, you should go and make workplace data protection laws because we haven't bothered to do it at the EU level. Please do it. For example, in Germany, there could be rights for works councils relating to data processing. So here again, what can the legislator do? In this case, what can the national legislators do? Well, they should use Article 88 to create national workplace data protection laws, and those laws should create explicit collective data rights for worker representative bodies like works councils. Third, right to an explanation for automated decisions. Of course, those of you who are GDPR nerds, you know we have Article 22 GDPR that sort of gives us this. Legal scholars have spent a lot of time debating whether there is actually a right to an explanation in Article 22. It's very complicated text. But mostly we agree that this right should exist, definitely in the workplace. And the EU legislator, actually, I would say, should clarify this. If the EU legislator does not clarify this, national legislators should do it in the context of making national workplace data protection law using Article 88. Finally, validity of decision-making or data processing procedures. GDPR provides that personal data must be accurate. And under Article 16, it provides a right to rectification of inaccurate personal data. So if personal data is found to be inaccurate, the person whose data it is has a right to have it either corrected or deleted. However, what if the data are accurate, but the algorithm is wrong, right? Or if it's implemented incorrectly. We all know that programming is hard. There's a lot of bugs in every piece of software that we've ever written or used. And some of these AI tools are simply scientifically unsound. The GDPR actually does not explicitly require that data processing be valid, only that the data involved must be accurate. So there are several ways this gap could be closed. One way would be to create an explicit right to valid data processing. It's also possible that a change to the law is not needed for this one. For example, the European Data Protection Board could interpret a right to valid data processing into the principle of fairness. And maybe some strategic litigation could be a way to get that done. So that's it. Those are the 4 gaps. We have a lot of papers about this. There was a special issue of this journal. If you like to read journal articles, have a look at these, or come talk to me about Article 88 GDPR. Thank you.
Thank you so much. Now is the part that we are most excited about. So we have about 15 minutes for your questions, remarks. We also encourage people who are watching us online to write their questions in the chat. Justin will take a look at those, and I will try to address those as well. So, would you like to have a question? Do you have a question? Okay. I think I'm just going to hand over the microphone.
Hello, Anna Karas. I work in the EU liaison office of Verdi, the United Services Union in Germany. First of all, thanks a lot. That was really totally interesting. At the ETUC Congress, von der Leyen announced that she wants to regulate algorithmic management in the workplace. What do you think trade unions should put on the agenda? How, I mean, it's really a big question, but what would be your 3 most important points she should go forward? Do you think a revision of the GDPR would be sensible, or an enforcement directive, or something totally different? That would be interesting.
Okay, how about we collect 1 or 2 more questions, and then we try to... Okay, if not, then maybe Justin or Six, do you want to say something? Each of us 3 points, or each 1 point?
I'll take a liberty to take 2.
Yeah, okay.
No, really good question, not an easy question. Well, 1 I think is easy. So when you talk about algorithmic management, you have right now, of course, the Platform Work Directive that's being negotiated, and there you have some articles that cover transparency of algorithmic management, information rights, etc., etc. But that only holds for platform workers and not for all workers, right? So it's an obvious thing, and I know that in the Commission they actually discussed that, but they found it too politically sensitive, and apparently there was not enough pressure from the outside to make that happen. So that, I think, is an obvious one. That's clear. Then, for the rest, when you talk about algorithmic management, a lot of that is just boring stuff about implementation, to be honest. So if you look at the AI Act, for instance, they also want to cover this. They also want to cover the workplace, right? But in the law as it stands now, it talks, for instance, about, I don't know, we need human-centric processing or something, or we need data it needs to be based on data that is representative. But it's not at all clear what that means. And that will all happen at standardization bodies that are completely unaccountable. We don't know who is in those bodies, and they don't have to say who worked on those codes. And I think there, for instance, unions are underrepresented. I think there's 1 seat for unions, but they also just don't have the information, they don't have the expertise, the time, etc. So that is where the beef is, and we need a new process to make that more equitable and to actually have workers, unions at the table where it matters, because I think that's where the law will be decided. So those are my 2 points.
I will follow up because I think that actually algorithmic management is one thing, but in order for workers to have stronger rights facing algorithmic management, we need to address the topic of collective rights. So what Six already said, I mean, we already have existing frameworks, but this algorithmic management platforms provided a shock to the collective rights, and the collective rights define who and how can negotiate algorithmic management, and this is just a big mess. It's a big mess because GDPR allows each country to deal with it differently. So Article 88 creates this flexibility. So we are just at the beginning of figuring out how unions or other collective actors could make use of that. So whether it would be to use the existing frameworks to regulate that on national level, or whether to create maybe a new framework on the European level that addresses not specifically or not only AI or algorithmic management, but also how to somehow systematize this and also take account of countries that have lower union density, weaker collective bargaining agreements. I think that would be very important. Six, do you want to address something, or are we? Okay.
I've got 3 things for you. I'll be quick. Enforce GDPR. Enforce GDPR. Enforce GDPR.
Okay.
Yeah,
No,
sure.
that was only the first thing. Enforce GDPR at work. Right? The European apparatus and the national governments need to put resources into enforcement. Don't get distracted by AI. GDPR covers AI. AI is not a separate thing. It's data processing. Finally, the European apparatus should encourage member states to use Article 88.
Okay. Johannes and then...
Hi, my name is Johannes Höller. I'm a PhD student from the Hugo Sinsam Institute, and my question goes to Joanna. Can you explain a little bit more about the project of resisting the algorithm? Like, do you have done like field research about how strategies the writers use to get bypassed without get punished, or how this works?
Mm-hmm.
Thank you.
This is very exciting to be in one field for a couple years and to really observe how it develops. At the beginning, when we entered the field of workers organizing, whether informally or with the support of unions, very early there was NGG organizing outside of Berlin and FAO here in Berlin. All the workers talked about was algorithms. The entire meeting would be just devoted to the topic of, okay, has the algorithm just changed? So this is already sort of resistance. If you, as I said, if you try to deduce how it works, if you, even sacrifice your time to do trial and error, and maybe even sacrifice your standing on the platform, and then you do it with the intent of helping others, that's, in my understanding, resistance. We, as researchers, were very early confronted with the challenge of how much do we want to talk about these practices. So this is something, this is misbehavior, this is about avoiding punishment. The more we talk about concrete cases of how workers do this, the better the platforms can respond to that. So this is a little bit like a technical race between hackers, You find a loophole, the platform finds a patch, so you look for a different loophole. So this has gone on and with masking GPS in many countries, and it's actually been a loophole that's closed. So we were able to talk about, for example, exchanging the shifts, but that's just because Deliveroo left Germany and it's no longer relevant. So this is why I struggle to answer a lot of questions, answer this question. But I want to mention something else, is that now everything that workers talk about is no longer algorithms. Now what they talk about is works council law. So the strategy has changed. Now these informal groups and workers' collectives are interested because in Germany, we no longer have the self-employment problem. Most food delivery platforms use employment, which means that workers have access to the co-determination system in Germany, either through unions or by creating a works council. And this becomes a primary focus for many of these groups. They want to test the limits of the collective labor law, and this is very exciting, even when these efforts are not successful because of, for example, union busting practices. But the next step would be to connect these two, if you know what I mean. To connect the knowledge that they gathered through many years of working about the algorithms, and to say, you as a works council, you can maybe work on a work agreement or a collective agreement that includes algorithms in it. I think that would be exciting going forward. But you had a question.
Yeah, my name is Mirko Herberg. I work for Friedrich-Ebert-Stiftung, coordinating the Global Trade Union Project. I want to ask you, how do you honestly see other unions doing? Are they up to speed in tackling these challenges, both in what you mentioned, sort of looking at the institutional power, laws and regulations, and also on building the associational power? Are they up to speed? And if maybe not, what do you think, are the impulses that need to be given where they should focus on?
I can try, but maybe
I can try. I have a short answer. The answer is no, and that is not a criticism, because the DPAs, the data protection authorities, are also not up to speed, and that's their only job, right? And you know what's really funny? If you ask the engineering team at YouTube who runs the algorithm that decides whether or not this video or that video is going to get paid, it's going to get ads, they also don't know how it works, even though they made it. So nobody fucking knows. And that's not a criticism of the unions. It's really hard.
Justin, you wanted to say something?
Yeah. No, I mean, I'm definitely not the expert on this, so take my words with a pinch of salt. From my experience, there are good things being done. For instance, in Austria, also there, of course, you have the Arbeiterkammer Institute, so they're quite active also in educational activities. But in the end, it all comes back to the fact that this is really difficult, and it's also because the technical reality that we have created, or we, not me, but that we live in, is just very ill-suited for works council representation, for union involvement. I mean, take the reality of software. It's being updated constantly. So in Germany, what does the law say? It says that for every significant update, new introduction of a system, somehow the Works Council should be informed. That's completely unrealistic. That is not, I will say that happens nowhere. So technically everybody's in non-compliance. So I mean, we also have to think about new ways to deal with that. That's why I focus always on standards and like focusing on the software to make that compliant. And I was last week, I was at a conference where somebody came from the US and she said, it's not surprising because a lot of the systems have been built in the US and we don't have any works councils, we don't have any union representation, so it's not built into the system. Deliberately not. And you see that we have those problems across the board. Social media, same story, right? We have a lot of problems, we want to regulate the big tech social media platforms, but it comes from a context where they don't have, free speech is absolute. So that is optimized in the platform. We have a balance between constitutional rights. So it's completely ill-suited for our context. So that's why I really think we need to look at the software, because otherwise this is going to be really an uphill struggle, because you just cannot check that. If the software allows you to micro-monitor everyone and it's based from the cloud, you can have all sorts of updates that also the employer doesn't actually know about or doesn't understand, because that's the second point. If you ask employers, they also don't know. They don't want to give transparency to workers because they can't.
Because they don't.
Yeah, they're clueless. That's what Works Council's members tell me when I talk to them. So, yeah, it's also about the software.
I think it's a very good point about this technical reality that we're confronted with, but it's also social reality. Platform workers case reveals that it's hard for unions because these companies also use loopholes in our social systems. So they go to big cities because they know that they can capture a workforce that is migrants, students, precarious workers, people that in principle are getting this job for short term. So this is a basic problem, I think, for unions. I think they have done a lot of very good work to create supportive environment to sort of share their resources with workers, and also supportive discursive environment, just to say this is an important issue, we care about this, we want something to be done, whether from the bottom up or from top down. The workers feel that, but they're not primary candidates to join a union. That's why they form these informal groups, collectives, because they know they're going to be at this company for 3 months. They say things like, I want to do some worker organizing because I know I'm going to be out of this company in 3 months anyways. So I might as well do something for others while I'm here. This is the opposite of logic than the unions say, which is that we should build membership, stable membership, and work to support our members. So I think what union can learn a lot from these new actors about how to organize more quickly, maybe in campaigns rather than long-term strategies, but also, like how to capture old practices. So whether they're just algorithmic resistance practices or these legal practices, right now individual workers go to Berlin court to fight platforms. I think if they had more support from the unions, it would be very helpful.
I'll wrap up with one sentence also in response to that question. I stand by my earlier answer. No, they're not. But it doesn't mean they're doing a bad job. They're actually doing a good job and doing the right things in a difficult situation. And of course, the bigger and more powerful the existing union is, the more other problems they've had to deal with in the last few years as well, right? So it's not like this is necessarily the highest item on the union agenda.
I think we have also this expectations that laws and institutions will act fast, but we are right now defining rules for more like the next generation. I don't think we should expect something in the next couple of years.
There's one question online, and then you can answer it very briefly. We need to cut you off.
Of course, yes.
Okay, so I didn't see that on my screen, but...
Can you? It's a person they already turned off their camera.
okay, wants to ask it live, okay. Can you give him access? Because I don't think I can.
He has access, but maybe he just turned on his camera because he doesn't have a question.
Yeah,
I
because I
think
don't see a
maybe
question in the chat, to be honest.
I said that we said in the chat, so now we wrap up.
Yeah.
Justin, do you have some final remarks?
Okay, we're over time, really short. I take back my words on new laws, and I agree with 6. We need enforcement, enforcement, enforcement. Second point, standards, yes, please. And third point, I agree with Joanna, we need unions to become much more active, explorative, use legal strategies, go to the court, test the law, because often we don't actually know what the law means. It's not concrete, so you only learn in court what the law actually means. So yeah, we need a max Schrems for workplace data processing. That's
and that will be next year. One of you sitting in the audience will be up here telling us how you've done it.
I think there's just so many actors that are trying out new ways, and now is just the time to capture the knowledge that has been generated and cooperate better across different actors and also across borders. So thank you so much for joining us for this session and for your questions, and we wish you a good conference.
Thank you, folks.